Every Tuesday, we do have immigration updates, and we do take live questions every Tuesday from 5 p.m. Central Time to 6 p.m. Central Time. Emily, what do you have today to discuss?
Yeah, headlines have again sparked fear, this time among naturalized U.S. citizens, because the Department of Justice is talking about launching a widespread denaturalization campaign. So we'll talk about how real is this threat, what the law actually allows, whether naturalized citizens really have anything to worry about, and try to cut through some of the panic and get to the truth there. And then we'll talk about this mystical golden visa. I mean, imagine being able to buy a green card for $5 million. That's what Trump is claiming. And he talked about it back in January, saying it would be up and running in 2 weeks. It's been a really long 2 weeks. We're now into July, and we still don't have anything other than a website where you can put in your name and email address, and it tells you your journey is beginning. So we'll look at, is this something that is actually legal for the Trump administration to do? And what would be the benefit of it? And lastly, the one big beautiful bill comes with a jaw-dropping $170 billion in enforcement. Um, how is that going to fall onto the shoulders of legal immigrants? We're going to see more compliance, things are going to get harder, more expensive. How does that impact families, workers, and employers who are following the rules?
Emily, the denaturalization process involves that the government has to file a case in the federal court against the individual. Previously, I always used to think that it's only if somebody lied. Let's say, for example, if they have a domestic violence and they did not disclose that information, or they have some major crimes that they did not disclose the information on the naturalization of something major crimes, and then later on, the USCIS finds that they have wrongly issued a naturalization for citizenship for this particular individual, they could go after the individual and denaturalize it. However, the June 11, 2025 memo tells a little bit different, that they say that even if the crimes have been committed after after they got the naturalization, the Department of Justice has a priority to denaturalize them, given a list of many things, but also left it open for the administration to add in the things. Now, of course, we know that some major crimes, they may denaturalize the people, but they also left it open for the people that left it open for the interpretation of the Department of Justice. Have you seen in your experience of 20 years anybody getting denaturalized other than reading in the books, Emily?
No, never come across an actual case in our practice. It has happened, it made headlines a few times during the previous Trump administration. So I think they're just moving along that path. But is it something your everyday, naturalized citizen needs to worry about being denaturalized? I don't think so. I think that it's generally been reserved for cases of, gross error, major crimes, that sort of thing. And there is more oversight from federal judges in this process compared to pretty much any other process in immigration, where, typically an N-400 application, it is the USCIS officer that is adjudicating this. Here, it's an actual federal judge. And they are aware that it's quite a high bar to actually prove that someone should be denaturalized. So although there's, again, a lot of headlines about this, we might start to see some sort of targeting of people, but I don't think it's going to rise to a level where most people have to worry about it. What do you think about that?
I agree, Emily. Most common people that are there should not be worried about it unless it is a major crime. It's not that I'm encouraging anybody, but I'm just telling, if it's a DUI, that definitely doesn't look to be in the list that they want to do it. But if there is something, drug cartels, criminal organizations, anything major like that, seems definitely there is a possibility that they can go, but not for minor crimes. They should not be able to do it. And as you rightfully pointed out, Emily, anytime we go to federal court, when we have something wrong done by the administration, that is the last resort that we take to the federal court. Here, if they want to denaturalize, they have to go to the federal court, not the individual has to go and petition in front of the federal court. The burden is on them to go to the federal court, not on this particular individual, even though it is doing a lot of circles around in the news channels. So, but at least for most of the audiences that are belonging to our channel, though, I don't think so. Anybody should be. I would say that very less people. I would say anybody should be worried about this one. Absolutely. Um, unless anything else, Emily.
Yep, I think we can move on to the gold card, the golden visa. If you can pay $5 million, you can get we don't even know what it is. It's not really a green card. It's maybe a visa. We don't know. Number one, it's not law. There's nothing in the Immigration and Nationality Act that provides for it. It's just an idea that was floated in various political circles, not grounded in legal reality. Generally, right now, US immigration law does not permit green cards in exchange for cash. All of the green cards categories are based on employment, job creation, family ties, humanitarian protection, something that Congress through statute determined is how we get a green card. And it's not something that a president can just magically create.
He said that the gold card holders are not subject to the worldwide tax system. That means, let's say, for example, somebody made $100,000 in the Middle East. There is zero taxes there in some of the countries. If you are a green card holder or a U.S. citizen, you are subject to the worldwide income. So let's say you have an apartment, you sold it, and you made $1 million in Dubai. You will be subject to the US tax rate here because you made a profit of $1 million. Now, even though the UAE government might have tax, that's the rules for the green card. Now, when the Trump presented it, he said that no, they will not be subject to the worldwide income, but then that requires amendment in the IRS, which requires Congress to approve it. He can't just come up with saying that, okay, I'm going to issue the green card, or I'm sorry, I'm going to issue the Trump card, or sorry, gold card, and you just go to the website of Trump website and get that thing. That's really a big joke, though. Not only that, Emily, that we have seen a lot of people calling us for applying. I want to get the green card. At the most, our law firm, I think so, you reported one person that may have called you and said that he wants a green card, but none other than that, we have not noticed any demand for it at all, even if by any chance this would have been. So it's utter flop. It's not legal, and it most probably will not be there at all. Anything else, Emily?
All right. Yeah. Now we've got this one big, beautiful bill that passed with this $170 billion planned for enforcement. Shouldn't that really just impact the undocumented population that they're trying to go through and deport all of these people? How is this enforcement bill going to impact legal immigrants?
Definitely, it's not going to be good for legal immigrants. The enforcement is going to put a lot of hurdles on the employment, people who are on student visa, people who are on work visas, people who are on the process of getting a green card, people who are dependents in United States. All these people, it is going to be more burden, more hurdles for the people. This $170 billion is going to be a big burden for the legal immigrants. Now, Emily, in the election, the Trump administration clearly said he is going to be after the illegal immigrants. But of course, when it comes to the practicality, it seems that he went after. He may be going after the illegal immigrants, but when it comes to us, though, we represent the legal immigrants. We see a lot of problems for the people who are legally trying to stay and in United States is putting a lot of hurdles. Recently, we have seen notice to appear for some of the cases where within the 60 days period, they've been sent to the deportation proceedings, even though they're in the 60 days grace period. And the judges now, I recently spoke with a guy, and the judge says that he doesn't understand. He postponed it until February. That means that this guy will be in trouble until February of 2026, though, having a lot of problems, may not be able to work, and may not be able to get a status. So all these problems will magnify by this $170 billion funding that came to the CBP, that is going to go to the Immigration Custom Enforcement. Very less amount seems to be going to USCIS only.
Yeah, even though USCIS isn't, getting this funding, they are being repurposed. They're supposed to be a service agency, a benefits granting agency, and now it's being folded into this whole enforcement apparatus. That's going to take resources away from adjudications and processing, which means we're going to be focusing on fraud detection, FDNS, site visits, extreme vetting, all of this additional scrutiny, which really does not bring in a lot of fraud. You don't find that much fraud and abuse in these employment-based categories. All that's going to do is make everything take longer. So now you're going to have to file in premium processing to be able to get your extension on time or get your change of status on time. It's going to cause unnecessary RFEs, unnecessary notice of intent to deny. We talked before about how we were seeing on I-765 applications for F1 students who are applying for an OPT or a STEM OPT, where maybe they had some sort of law enforcement interaction before. They're getting a notice of intent to deny the OPT card saying, we want to use our discretion to deny your card because you had this run-in with law enforcement. So you need to provide us, number one, with all of the arrest records, and then prove to us that we should use our discretion favorably to grant you this OPT. Now we're seeing it in I-129s for H1B. They're saying, well, we saw that you were arrested for this. We're going to send you for biometrics. And now because of what's in the arrest report, we think that you don't deserve an extension of stay. So we intend to deny it unless you can prove to us why we should give favorable discretion. What are all of the factors in your favor for us to give you this extension? So all of this is going to make everything take longer, increase uncertainty, fear, create additional backlogs for people going for visa stamping. None of it is good for legal immigrants, even though legal immigrants supposedly are not the target of any of it.
Anything else, Emily, before we get to question and answers?
Nope, we can move forward.
Cricket Lover has this question for everybody, but I want to answer too. I belong to one of the everybody. His priority date is April 2017, EB2 and EB3. What is the future of him? He's an H1B. Well, most likely that if you have a child born in United States, assuming that you came somewhere in before 2017, and maybe one of your child is born in United States, that child will become 21 and probably get you the green card based on the way the priority dates are moving. That's what the projection seems to be right now. Now, until that, definitely you will have to hold on and stay in United States, or you can even, since you have an I-140 approval, you can always go to India and come back whenever your priority date is current. But it seems to be that it's going to take a long, long, long time for you to get the green card, unless there is some miracle that happens.
Tech Topic says, can you please share insights about self H1B success rate? So this is the entrepreneur H1B where you own your own company and your company sponsors your H1B. It became available in January 2025 through a regulation put forward by the Biden administration. We have been filing them. We have been getting approvals. I have yet to see a denial. I don't even think I've seen an RFE asking for additional evidence before they approve it. So it seems that at least the initial 18-month approval is going quite smoothly. We'll have to see 18 months from now when it's time to file that first extension, if that will be as smooth or if we are going to have a higher burden to prove that, number one, you were doing the job duties you said you were doing, and number two, that the company has grown, the business is there to support a specialized specialty occupation work.
Uma is asking the question, is it the right time for going to stamping in India? I don't have an option for Dropbox. Absolutely not. This is not the right time for you to go for Dropbox. Ramesh from Facebook has this question that since the pilot program is over, can we now move on to actually getting the, can we now move on to get the stamping done within the United States? This administration doesn't seems to like the stamping done in United States. At least they have not expressed anything about it, and the way that they are sounding it, it doesn't look like they're going to have they're going to do the stamping in the United States. At least this administration doesn't look like it all.
Joyo says my spouse is on L1B and wants to move to H4 and apply for the H4 EAD at the same time. Can he continue to work on the L1B until he gets the H4 and EAD and converts to H4? Yes, assuming that the H4 and H4 EAD are approved at the same time, that's no problem. Just because you filed the H4 and the H4 EAD doesn't mean you have to stop working on the L1B if your L1B is still valid while it's pending. The big risk is if your H4 change of status gets approved and the EAD is still pending. In that situation, you have to stop work until you receive the EAD because you're no longer in L1 status.
SNH is asking the question from YouTube, can I travel to Canada for a couple of days using the advanced parole while the 485 EAD is pending process? My home country is India. We do not see any problem whatsoever at all for you travel on advanced parole. Your EAD will still get adjudicated without any problem.
Adi says, I have a question on TNs. Does having a Bachelor of Science in Computer Engineering plus 10 years of experience as a software engineer qualify for the TN engineer role? There was a recent policy update about TN engineers, focusing on software engineers. Up until that point, for a TN software engineer, at least for our firm, we generally would ensure that the employee had a software engineering degree. We don't count experience towards that in the TN category. But now the question becomes, can a software engineer even get a TN? Because they're saying that it has to be a position that licensure is available for, like a PE license. I'm not sure if there's a license out there for software engineers with the different states. So it might be more difficult to get a TN under the engineer category. Now you could potentially get a TN under the computer systems analyst category if your job duties fall under that.
Question from Jitendra Bonagiri is asking this question. Is using an IPTV, it seems true that that's internet TV, that as I Googled it out, grounds for deportation? Absolutely not. That's definitely not.
Anirban says, I recently received a medical RFE for my 485 that was completed in 2020. Priority date still not current. Is it normal to receive a medical RFE even when the dates are not current? Nowadays, anything's normal. They do whatever they want. For a time, they would wait until about 6 months before the priority date was about to become current and send a slew of medical RFEs. So that they wouldn't expire while you wait. But now, because once you get the medical and submit it, it no longer expires. There's not really a need for them to wait until the date is going to become current. They can go ahead and ask for that now. So we are seeing that. I've got about 5 RFEs on my desk right now for 485s asking for updated medical exams, and the dates are not current.
A question asking for if I'm visiting US Virgin Islands, so do I need to carry the the Indian passport and US visa? We recommend strongly that you carry the Indian passport and US visa. The reason is that it's they do a lot more checkings though, because it's very border to a lot of different countries. including the Caribbean islands and all those things. People can just drive, go there in the motorboat kind of thing. So there is a lot more checkup there. So I definitely recommend. Now, if you are in Dallas, would I recommend you to carry the passport and visa? No, I don't recommend if you're in Dallas, but especially when you are at a border town like South Party Island, or when you are in this US Virgin Island, or probably Puerto Rico, which is also adjacent to US Virgin Islands, you should carry the Indian passport and of course the visa or the I-797 in the respective cases.
RA says my STEM OPT is pending and I'm in the 180-day auto extension. Also has an H1B change of status pending. That was filed during the 180-day auto extension. And he wants to know if the STEM extension gets denied, will I be out of status or on cap gap? So it depends on the timing of the denial and the reason for the denial. So if they deny the STEM extension because maybe the I-20 was not issued properly or it was expired or didn't have the proper authorization for STEM OPT, has nothing to do with whether you maintained your prior F1 status or not. From the date of the denial, you're no longer in F1 status. You should get the 60-day grace period at the end of F1 stay. And if that gets you to October 1st, that allows you your H1B change of status to still take effect without any issues. But if the denial happens and says that your prior F1 stay was somehow unauthorized, or you failed to comply, or you exceeded the unemployment days or something like that, and they determined that you were not properly maintaining your status, then they don't give you the 60-day grace period, and then you may not be able to get the change of status to H1B approved. The H1B can still be approved, just without the change of status portion, meaning you'll have to exit the US, apply for the visa stamp, and then come back on October 1st.
Question from YouTube. This gentleman's name is Speak Truth Straight On. Is it a good idea to apply for naturalization under the current administration? Yes, yes, and yes. At this point of time, of all the immigration departments, now there are different uh, there are different agencies that operate immigration. Like, for example, Immigration Customs Enforcement. There is Customs and Border Protection. There is also the State Department, which issues visas and sometimes green cards also. There is USCIS. The naturalization is administered by USCIS. Out of all the four departments, I'm not telling that USCIS is better, guys, has become better under this administration. But of all the four departments at this point of time, the least affected is the USCIS. We are seeing a faster adjudication in the naturalization. Things are not going to get any better if you're a green card holder, you're eligible to apply for citizenship. Please do it. Now, if you have any misconceptions, there are a lot of people who have conceptions. Oh, I want to have a property in India. Can I do it? You can have a consultation with me. I'm a lawyer in both countries, in India and also in the United States, licensed lawyer in both countries. You can consult with me or anybody like that. And there are some things we can remove the probabilities, then you should apply for citizenship. The only people that I tell not to apply for citizenship is somebody has a political ambition in India. They want to become MLA, or they want to become MP, or they want to become they want to hold a political office. Then I don't recommend them to become a US citizen. But rest everybody, I tell them to become a US citizen. People say that, oh, I can't hold the agricultural properties. No, the rule in India says that you cannot buy any more new agricultural properties. You can still hold the agricultural properties. You can, if you already have it, and you can inherit the agricultural properties. You can sell the agricultural properties. What you cannot do is you cannot buy any new agricultural properties. That's the only thing. Now, there are ways out in India also. If you still want to buy an agricultural properties, there is something called NALA, conversion of agricultural property into non-agricultural properties. Before buying, you can convert the property into non-agricultural property. It's easy deal. You just pay a legal money to the MRO's office in a DD format. They will convert it, and then you can buy it. So there are many ways that I tell people that who doesn't want to apply for citizenship, please speak with an immigration lawyer to find out why you're holding it, because it's not advisable for you not to apply. Please apply for citizenship. If you are eligible for it, apply for it.
Kendra says, my I-94 end date is September 30th, 2025, but my visa end date is August 30th, 2025. Which date do I need to consider for H1B extension? So if by visa, you're talking about the stamp that's in your passport that has your picture, it mentions that it's H1B, it has an issue date, it has the consulate name on it, that stamp is completely irrelevant. The only time you need a valid visa stamp is when you are physically entering the US. Once you're here, it's always your I-94 that controls. So if that's what you're talking about when you say visa as your end date, it's the September 30th I-94 end date is the date you need to go by.
Cousins' kids are going to school in India. They're studying first class. Is there a visa? Kids can come into USA into US schools. Now, I know some middle schools and high schools that are private schools that issue an I-20 even for the young kids, but I don't know anybody who's going to issue the primary. These are residential school that I know about. These are private school that issue an I-20. There are some in Texas area and everywhere too. But yeah, you can check around. There are some private schools that do issue an I-20s for young children also to come into the United States and study. It is possible for them to come on F1 visa.
Chandrakant says, my priority date is July 2013, EB3 India. Is there any chance of the filing date becoming current in October 2025? Well, we did go over this a little bit last week because we do have the new inventory that came out. I don't exactly have it going up till July 2013, but I can say that for EB2 and EB3 combined, for us to get through all of 2013, there's 17,000 people in line. There's only 5,600 green cards available each year if you combine EB2 and EB3, which means it's going to take 3 years to get through 2013. So I don't know if that date would become current in October 2025.
A question from Joe. My spouse is an L1B and he wants to move to H4 and apply for EAD at the same time as she has an I140 approval. And if this husband files for H4 plus EAD, while the L1B is still valid, can he continue working until the H4 EAD has been approved? The answer is yes. If the H4 EAD is pending and it's not yet approved, the L1B is still valid. You can continue L1B. I don't see any problem whatsoever at all.
Sai says, I've been following your channel for the last 7 years. Never have I been so nervous looking for Tuesdays because it's been bad news every week since January. Is there any positive news? Yeah, we've been through this before. If you were here during the previous Trump administration, it was the same thing. Every Tuesday, there was bad news and more bad news.
Emily, I correct I want to just, it was every Friday at that time. We used to have a special session on Friday.
Yeah, we would have to do a special session because they would always drop weird things on a Friday. So we would do live breaking news on Friday. So we haven't had to do a ton of those yet. I'm sure they're coming. In terms of positive news, not really. I mean, I expect more negative news to come. The silver lining up to this point is in my regular run-of-the-mill filings that I do day in and day out with USCIS, H1s, L1s, I140s, 485s, by and large, I'm not getting any more RFEs than I was before. I'm not seeing denials like we did with the previous Trump administration. So far, things are pretty smooth, other than these weird things happening with NTAs. It's small number of people so far, other than these weird things happening with biometrics and RFEs about arrests and that sort of thing, which is not the majority of people. So the majority of filings that we're doing in our office are not seeing these weird things happening. They are business as usual for now, knock on wood. We'll see how long that continues.
Emily, are you still getting the H1B 3-year H1B extensions? Because in 2017, in the Trump administration, you used to get 6 months and 1 year extensions. Are you getting 6 months or is it 3-year extensions that you're getting?
3
if
years.
The people are, okay, good.
Yeah, thankfully, we're still getting 3 years extensions. No problems with that.
Okay. Joe is asking another question. The administration says that after completing the undergrad or graduation, you will be automatically getting the green card they're going to attach. That's what Trump said. Is that going to happen? Absolutely not. That is, I don't know what to say, where he must have been, I don't know what he was smoking at that point of time when he said that, but definitely no, he's not going to do that. And there's no proposal for it right now for that if you graduate in bachelor's degree or master's degree, that you will be given a green card. Absolutely not there.
Neumann says, is there any estimate of how many EB2 and EB3 people have migrated into EB1 India in the fiscal year 2025? No, and I don't think anyone is tracking it. I don't think USCIS has a way to track it. So unfortunately, no, it's anybody's guess.
Susha Shushil has this question, birthright citizenship. I am expecting a baby in August in Ohio. Can we apply for the H4 for the newborn? Definitely you would be able to, but I definitely don't want to go there right now. We are going to update definitely this week. We are going to have another session on the birthright citizenship. What are the things that you can do? Do you need to move to blue states, the 22 states that probably you'll be better off moving? You may be better off. We'll address that to the democratic states to have the child born there. That probably maybe, but we're going to bring some experts if needed to that. We are expecting some relief coming from the courts this week. If not, we're going to conduct by end of this week. Definitely, if the person does not get the citizenship, they will give an option of applying the H4. We can apply for the H4 in United States, but I am not looking forward to represent a kid who is born in United States to file a H4. I am not looking forward for it. Hopefully not.
Prime says, my employer communicated that the I-140 was erroneously rejected by USCIS and they're going to file it again. What are the risks of USCIS rejecting it again? I've already have the priority date from my last employer. So assuming you're not running up against the deadline for filing the I-140 based on the PERM expiration date, generally when we refile after an erroneous rejection, we do get it receipted properly the second time around. Had a few cases here and there that we've had to submit multiple times. It's just a matter of getting it in front of the right person and marking up the petition and the putting bright colored paper explaining, not to reject it in the mailroom and that sort of thing. So it does happen. It is not uncommon. It doesn't happen every day, but it certainly happens.
Question. Can a person who comes into United States on H4 apply H1B within 90 days after coming into United States? This question is coming from Ravi. The answer is yes. They can even apply the next day they come into United States. Now that sounds a little bit contradictory that what you may have been looking into. The reason is that if people are coming on a B1, B2, or probably an F1, there may be some restrictions with regards to the 90 days. H4 is a dual intent visa and has no problems whatsoever at all to apply for change of status within a short period of time after they coming to the United States. Even the day they landed, can they apply for H1B? Absolutely, they can. We don't see any problem for the H4 people.
Raj says, I'm currently working on H1B and I have an AOS EAD. How can I switch from the H1B to the AOS EAD without changing jobs? You just snap your fingers and it happens. Or you can click your heels 3 times like Dorothy from Wizard of Oz. You don't have to do anything. You just say in your head, you know what? Tomorrow I'm going to start using my AOS EAD. Now you're using the AOS EAD. Nothing has to be done with USCIS. You don't have to tell your employer. Your employer doesn't have to do anything. At some point when your employer needs to re-verify your I-9 when your H-1B is expiring, at that point you can give them the EAD card and they can re-verify based on that.
I mean, this question is coming from AJ from X Twitter. Is it expected to have a second lottery?
Good question. I'm going
I
to guess no,
Yes,
and it is a guess.
I'm going to guess yes. Here is the reason I think so, that when you see that there has been a drop in the amount of people who file the H1Bs by 26% this time as compared to last year. And also, there are a lot of people, after they filed it, they did backed off filing the H1B either because they did lose the job. So I am expecting, but let's see whether Emily's going to be right or I'm going to be right. Hopefully for all of you guys, I'm going to be right. But yeah, let's see.
Rishi says I applied for the GCEAD renewal along with AP. Today I got my GCEAD approved. AP is still pending. Is there any chance that I would get a combo card? Well, I guess it depends on how you are knowing that you got the GCEAD approved. If you're just going by the online case status, it is possible that both got approved and that you'll get the combo card. Sometimes the AP online case status doesn't update. So you won't really know until you get the EAD approval notice. That I-765 approval notice will specify that the I-512 is included, or until you get the card in the mail and it says it's also advanced parole at the bottom.
Question, have you recently seen any denials of the H1B extension due to past dismissed criminal cases? It depends on how the case has been dismissed, but what we generally see for DUI or any small crimes, we don't see any problem at all. Their extensions are coming through without any problem. But if it's a domestic violence, we need to look into very closely what are the things that are being said. As of now, we have not seen any denials of the H1Bs, though. As of now, we have not. But if there is any major crimes, they could.
Wonderless says, what are the chances of I-140 approval with a dismissed criminal case? I got H1B stamped successfully recently. I don't think I've ever seen an I-140 denial due to a criminal case, whether it was dismissed or not. It is something that could come about, given USCIS's policy of discretion that they're seemingly to expand from I-765 now to I-129s. Maybe they'll expand it to I-140s, but at this point, we have not seen that happen.
There was a question that's coming. It's a bit odd question, but it happens to be that, in the weekend in my family get-togethers that was being discussed about, for 23 lakhs, so approximately about 25,000 or $26,000, they are going to give a golden visa in the United Arab Emirates. That's the discussion that was asking. One thing is, these countries like UAE, I mean, if you have to just, they keep on blowstring saying that they are so great and all those things. The entire economy of UAE is, I mean, equivalent to just Houston, Texas. I'm speaking of the entire country economy is just Houston, Texas. So it's just very small. It's a city state according to, and the GDP of the entire country is equivalent to that of Houston. So that's one theory that I will tell people what a UAE is. The second thing is that what they're offering is only valid for 10 years. Please look into those things because you are in USA right now and you're going to stay in USA for next 10 years. And you're going to pay this one $27,000 for only for 10 years. I don't know. I don't think so. It's worth it.
Mahi says, my wife's OPT got expired and she returned back to India, and now I received my H1B renewal copy, valid till 2028. Can she go for the H4 visa interview without my H1B visa being stamped? Yes, absolutely. There's no requirement for you to have an H1B visa stamp since you are in the US. And she just needs your I-797 approval notice in order for her to get the H4 stamp.
Question from Praveen. If I'm applying for citizenship, can I travel internationally during the time when the citizenship application is being processed? This is a very common question that comes. The answer is yes, absolutely not a problem. Now, there is a small step you need to do it. When you go for the interview, the officer will ask you, have you ever traveled outside the country? You say yes. And the officer will tell you when, and then you give the dates, and you just have to initial. That's it. Your citizenship is not going to be denied, absolutely not going to be denied if you travel. Now, only cautious is I'm assuming your trip will be less than 4 months outside the country. Now, definitely, if it's more than 4 months, I would definitely want you to contact. Well, 99% of the people will be less than 4 months. So most probably you would be fine.
Aranjita says the EB1B priority date is March 2023. Will it be current in October 2025, or when will it be current? Well, as we always say, we are the worst at guessing these things, and it is a guess. But what I can tell you is that EB1 India currently has over 15,000 485 already pending with priority dates before 2023. So they've got to get through 15,000 cases plus January, February before it gets to your date being current. EB1 India has historically gotten about 10,000 green cards a year. That may go down if more people from rest of world are using the EB1 category, but it's been pretty stable up till this point. So it might be a year and a half before we get through 2022 and start getting into 2023.
Scam exposure as his question. He's a naturalized citizen. If I'm convicted of domestic violence 1 year after I get my citizenship, will that be a problem? Could be at this point of time. We can't tell at this point of time how the administration is going to do it, because domestic violence is definitely considered to be a major crime. Will they denaturalize? We will have to see. You may want to keep tuning in. I mean, we always said that, once you become a citizen, you don't have to come to this channel. Now we have to tell the people that even after you get the green card, please come to our channel. Even after you get the citizenship, you please come to our channel. That's how the things are. You have to keep watching our YouTube channel. We can't give an update right now. When I look into the memo of what they issued, though, they said national security. That doesn't look like domestic violence is. Torture, war crimes, or human rights violations. It doesn't look like criminal gangs, drug cartel, or criminal organizations. It doesn't look like felonies. It doesn't specify particularly the domestic violence. It did specify the sex offenses, but it said violent crimes. Now, does it mean that violent crimes means domestic violence? We don't know at this point of time. So we'll have to see how the administration is going to implement. Any thoughts on that? What is that, Emily?
Yeah, I think they could try to do anything, and it'll be up to the courts to decide whether it's right or not. So we've got a long way to go on that. And this was the topic during the previous Trump administration, even when they claimed they were focusing on denaturalization and having this task force. I don't think there were that many cases where they actually denaturalized anyone before. So, well, this could just be, again, another kind of media ploy, a way to, sow fear and that sort of thing, and not actually result in anything. Satish says, can someone go back to their employer where they have the I-140 approval and resume the green card processing? What are the limitations? Yes, absolutely. You don't have to be working for the employer that sponsored your green card in order to receive the green card. It's all based on an offer of employment that you will take when you actually get your green card. The limitations are going to be the company. Do they want you back? And whether they withdrew the approved I-140. But even if they did withdraw it, they could turn around and refile it using the same old labor certification, even though it's expired, and kind of revive that I-140 to bring it back. We did that a lot in October 2020 because a lot of people had left their employer, moved on to a new employer. PERM was taking forever. Prevailing wages were taking forever. And if they didn't go back to the old employer, they were going to miss the boat and not be able to file the 485. So a lot of people were able to kind of resurrect that old I-140 and file with the old employer to be able to file then.
Srita Reddy from YouTube seems to be on a non-immigrant visa, and then she is trying to inquire how to look into the travel history of our children who are where to look into the travel history. There is nothing like that. And our children are US citizens. Sorry about the US citizens. There is no record for them. At least you can't see that in the CBP website. You don't need to worry about it at all. It will not affect negatively. Even if the children travel and they stay for the next 90 years in India and they want to come back, since they're US citizens, they can come back. Absolutely not a problem. Since they're US citizens, they can stay however long. So that's the reason why that history is not there, not available, not it doesn't need to be.
Garikid says, my friend filed the PERM in October 2024. When will it be approved based on the current timeline? Maybe by December 2025. I think right now we're getting approvals for cases that were filed in February, March 2024. So got another couple of months to go.
Ajinkya Joshi has this question. My 7th year H1B is approved. My I140 is still not approved. Is my wife eligible for H4 EAD? If you are on the 7th year, based on the PERM pending or PERM, absolutely, your wife is eligible for H4 EAD. You don't need to have an I140 approval. If you are in the 7th year, your wife is eligible for the H4 EAD.
Joyo says, after getting the PERM approval, I heard you need to stick to the same employer for the next 6 months. Is it 6 months after getting the PERM or after getting the I-140? It's after getting the I-140. So after you get your PERM, you have 6 months to file the I-140 before the PERM expires. Once you get your I-140 approved, if the employer withdraws that approved I-140 at any time in the next 6 months because you left the company, that process stops and you won't be able to use that I-140 to get continued H1B renewals, continued H4 EADs, or to actually receive the green card. But you do still keep the priority date. So you can start the process again with a new employer and still keep that same date.
Second. Anil Raju is asking this question. Can Trump sign an executive order to recapture all the unused GC and give it to the countries with backlog? It's a long shot, but curious to know. Yeah, it could possibly be. Yeah, it could possibly. I would rather buy a lotto for $1 and you have a higher chances of getting $230 million than the Trump administration issuing that executive order.
Viplav says, I'm currently on H1B in my 3rd year. My previous role ended and my employer withdrew my H1B on June 30th. So I'm in my grace period. Based on your live video, I'm concerned about people receiving a notice to appear. Would switching to B2 be a good option in my situation? Yeah, so in the cases that we have looked at, they did file a change of status to B2 or a change of status to H4 or had a pending 485 with an EAD that they could use. But all of those change of status applications were filed after the company withdrew, even though they were still within the 60-day grace period. It was the withdrawal that caused the NTA, and USCIS did not look to see whether there was an additional filing within the 60-day grace period and issued those NTAs. So if your company already withdrew, that could be problematic. The probably best thing you can do is file a change of status to have that pending to potentially stop that kind of notice to appear from happening. But we did see it in cases where people filed while they were still in the grace period, but after the withdrawal occurred.
Are you seeing any visa stamping issues for healthcare professional? This question has come from rph.dr. Are you speaking any positive or negative? That's a question that I'm speaking about. Definitely, we don't see any negative thing just because you're a healthcare worker. Definitely, we don't see. Do we see that, oh, since you are a healthcare worker, they are going to put a red carpet and give you the visa stamping? No, that is not true either. So you will be treated equally, not that you will be discriminated, neither you will be given any promotion because you're a healthcare worker. Is lottery Powerball only restricted to citizens and residents? A question from Travel Science Guy coming. Lottery Powerball is for everybody, even if you're a non-immigrant visa. Also, you can buy it.
Sai says, I have an approved I-140 and EB2. My current employer is filing an I-140, but only an EB3 because in the job description, they've not mentioned a master's degree as a requirement. What are my options to file an EB2? Well, if the job requires a bachelor's degree plus 5 years of experience, you can still qualify for EB2. But if they only mentioned a bachelor's degree and something less than 5 years, you cannot use that company's labor certification in order to get into EB2. You would need to be sponsored for a different job that has higher requirements, either a master's degree or a bachelor's plus 5, or file an NIW on your own in EB2 if you qualify for the national interest waiver.
SPG has this question. He got laid off. 60-day grace period is there for the H1B. What about the GCEAD? There is no 60-day grace period for H1B. If you got laid off, you need to find ASAP another job. Otherwise, you'll be risking your green card. Self-employment is allowed for the people who are on the GCEAD. So SPG, I strongly recommend that you contact an immigration lawyer ASAP if you don't have a job. If you do have a job, then you're fine. But otherwise, I do recommend that you contact an immigration lawyer for the possible solutions. RRB has this question. He has worked for 5 years on H1B, changed to B2 visa in USA and returned to India. Can he use the remaining 1 year left out H1B without going through the lottery system? The answer is yes. You can use the 1 year of the H1B without going through the lottery system. Absolutely, you can. A lot of people ask this question, can I use it in 1 year, 2 years, 5 years? You can use it in the next 90 years. But you will only be given that 1 year. If you go through the lottery system again, then definitely you know that you will get another 6 years. But if you don't go through the lottery system, you will only able to get 1 year. Also, I have a suggestion for you. If you can find a company that wants to file a green card for you, though, even though you are in your home country right now, the companies can file a green card for you. And if the I-140 is approved, then of course, instead of getting a 1 year H1B, you can get a 3 years H1B. And people ask question, when I'm in India, can the company file a green card application? Yes, absolutely they can.
SPG says, I was recently laid off and was on H1B. I have a GCEAD, which I have not yet used. Would the 60-day grace period be applicable
Emily,
to me? And got that one already?
Yeah. Travel Science has this question. Does doing a H1B job on receipt notice is advisable now? As Emily has been pointing out, she hasn't been receiving much denials. That's what we are. We are not receiving that much denials as much as we have seen in 2016 and 2017 in the Trump administration. So it depends on if everything is good, the company is good, and all those things. Yeah, it probably is worth. I would say the risk is very minimal for you if you move on a receipt notice if it's a proper job.
Ram Kumar says, for these H1B extensions, we keep hearing about biometric requests for cases with an arrest record. What if the case was dismissed and the arrest was deemed as detention only? Are we expecting any denials? It is too soon to really say. We've not yet seen the outcome of these cases where there was an actual arrest. I think it depends on the arrest report and what the police say happened. And that's where we get into not necessarily denials, but whether USCIS can use their discretion to deny the extension of stay request, to deny that I-94, if there are things that are not favorable to you in that police report and you don't have any balancing positive factors that you can use. And again, this is still in progress. I don't think we've seen the outcome yet in these cases. So it's going to be another 2 to 4 weeks, maybe even longer before we start to see the outcomes.
Are you speaking about OPTs, EADs, Emily, or H1Bs right now?
H1B extensions.
Okay, Emily, what about the article that you've written in May of 2025 with regards to the people whose services has been suspended because of some interaction with the criminal activity? Now, they are getting a RFE in the OPT and STEM extension. How do they respond to those things?
Yeah, so that's where I think the RFEs are a little bit disingenuous because all they're telling you to do is submit the arrest records. But I think that you need to go beyond that and assume that based on the arrest records, they could try to deny in their discretion. So for that reason, we would recommend also submitting any documentation you can that shows the positive factors of why they should issue an approval. For STEM OPT, I had recommended, or OPT, showing your academic performance, submitting your transcripts, showing your A student, awards you've received, honors you've received, show your rehabilitation efforts. Did you go through a counseling program? Did you do community service? What other corrective measures have you taken since your arrest? What kind of community involvement do you have? Are you participating in community organizations or student organizations? Are you part of an honor society? If you're already on OPT or CPT, proof of your employment, what is your employment, especially if it's in an area that is kind of in the national interest, or maybe you're a healthcare worker, maybe you helped during COVID or things like that. And then maybe a personal statement that explains the circumstances of the arrest, what lessons you've learned from it, what steps you've taken to avoid future issues, and kind of a promise that you will not have any additional interactions with law enforcement. So those are the things that I would consider submitting. Same thing for people who are getting this kind of notice of intent to deny or an RFE on an H1B extension, to give those kind of positive factors and whatever documentation you can that will outweigh the one issue that you've had with an arrest in the past.
Questions are coming from Ram Kumar with regards to the biometric requirements. Even if it's been dismissed, it's not even arrest, it's deemed to be detention. Now, I know the criminal lawyer tells you different thing. In fact, I just spoke, I was off the phone with a criminal lawyer in New Jersey. He was telling that the DUI is not a crime according to in some sections of the law of the New Jersey. So now, for the purpose of the immigration, it is. And this question I'm answering for Ram Kumar from X. If it is a detention and not an arrest, for the purpose, it is a negative interaction with the police authorities. You have to mention that. And yes, they are issuing a biometric first for those people who are being who are being dismissed and they were being deemed only for detention. Also, I've seen them issuing a biometrics. And I recommend strongly to follow what Emily has said just 2 minutes ago for detention also.
I think we are out of time for today. Thanks everyone for joining us. Highly recommend that you join us every week because we are seeing things change rapidly. We've got the birthright citizenship issue going on. We've got these NTAs going on. We've got these potential denials for discretion starting. We don't know what's coming next. So it's very important for you to stay aware of all of these issues and know how to move forward so you can protect yourself the best way you can. And you can do that by following all of our social media on X, on Facebook, subscribing to our YouTube channel, subscribing to our newsletter, because we do put out articles on our website and you can get a rundown of those every week when we send out our newsletter.
Thank you.